Morning. Yes.
My lord, may I please your lordship, my lord, item number 7. What happened, my lord? The petitioner have already died, my lord, leaving behind his only son, my lord, but he is not interested to proceed the case. Matters pertaining to, my lord, inaction of the police, my lord, in FIR, my lord, that may be closed, my lord.
You want to withdraw
Closed, my lord.
in item number 7. Your name?
Politician.
Heard Mr. T escape. Also heard Mr. K. Gogoi, learned additional senior government advocate for the state respondent. Stop. Health is there? Health and also Mr.
No, national highway authority.
Item number 7.
7, item number 7. Government is there, my lord.
Sending council health is also reflected in item 7.
Yes, my lord.
And Mr. B. Gogoi's learned standing council health. Stop. Mr. T. So SK learned council for the petitioner submits that in the meantime the petitioner has
Already died.
expired.
Expired, my lord, on 6 to 2022, my
On
lord.
6
to
to
2022, my lord.
2022. Stop. And he stop. He further submits that the legal heirs
Only
are-
son, my lord.
Huh?
Only son, my lord.
The legal heirs are not interested
My
in
lord.
pursuing the matter. Stop. In view of the aforesaid endorsement made by the learned counsel for the petitioner, this writ petition stands closed as being infractious.
Obliged.
I make mention item number 20, which I concern on the petitioner. Okay. Some,
20.
yes, Lord.
What is there?
No, I'm not there, my lord.
We have to take some instruction.
You are for?
Respondent.
Have you informed the other side?
Yes, Lord.
As prayed for by Mr.
P. Gogoi.
So and so learned counsel for the respondent number.
Respondent number, private respondent.
For the respondent with consent from the other side, list this matter on such and such date to enable the respondent to obtain the you want to obtain instructions, right?
Yes, Lordship.
To obtain instruction in the matter.
May I please your lordship. With regard to item number 47, my lord, I am appearing for respondent number 1 and 2, my lord. I am filing the affidavit today, my lord.
You wait, it's an order matter, but you are filing it today.
Yeah, my lord. I am filing it. In fact, they said like they will be needing some time.
Order matters, I would like to see the file before passing the order. So kindly wait. No mention for orders, please.
My lord, the two matters already disposed of, my lord. Two matters have been already disposed of, my lord. And in that case, my lord, some typographical mistakes are there, my lord. PR and something, my lord. So matter may come on Friday, my lord.
This court's order.
Yes, my lord.
Lordship,
Yes.
yeah, please. We had prayed to implement a party of UCO Bank actually because the concerned property is mortgaged with both the banks.
Yes.
Yeah. So the thing is that
Are you objecting?
yes, we have filed our objection to
You want to implead the Eco Bank?
UCO Bank. Yes, madam.
Yes. Mr. Ganguly, you're appearing for the UCO Bank?
No, I'm appearing for the Punjab National Bank. I am the writ petitioner, my lord. He is the respondent, private respondent in the writ petition.
He wants to implead.
He wants to implead. He is a
I
body.
have what happened is actually I have
Can the
filed my.
respondent seek for an impleadment?
What happened actually? They had filed the
No,
writ actually.
first answer the query that is posing. Can the respondent insist that a particular party be impleaded? At best, you may say the petition is not maintainable for non-gender of the party. How can you insist? What is your locus? Please satisfy the court that first.
Locus is there, my lordship. The PNB has filed one writ actually.
No, on law, not on facts.
On fact, because
Can
both
the respondent insist for arraignment of a party as a respondent? Please answer that query first.
my humble, I am sorry to say that at that point I may be not able to
Very
discuss
well.
it right now.
Check that point. Then.
Yeah, I will.
But because of this impediment application, my writ petition
Have you taken that objection?
Yes, my lord.
What is your objection? Let's see.
My objection, my lord, in the IA is that, my lord, precisely on the question of locus standi, my lord.
Where? Which paragraph?
Lordship will, my lord, come to paragraph 5 of my objection. IA civil 3518 of
Nine देखो. IA?
IA civil 3518 of 23. my lord.
But where is the objection? If the objection has been taken, this court will dispose it off right now. In that case, you ought to have looked into it. Ms. Borman, you're appearing in this
Yes.
matter?
Flag A. Flag.
CPC खोलो.
Paragraph 5. May I read paragraph 5?
Yes.
That in reply to paragraph so and so of the IA, the answering respondent denies the same principle. It is submitted that assuming without admitting that the same property is the subject matter of mortgage with two different banks, it is incumbent upon the concerned bank to agitate its rights in respect of the mortgage itself. There is no provision in law which authorizes the applicant to file the instant application for impleadment of UCO Bank on the ground of alleged prior mortgage. The intention of the applicant is quite clear to further delay and frustrate the recovery proceeding. The applicant has appointed himself as a guardian to protect the purported rights of the UCO Bank claiming the so-called mortgage. The WPC number so-and-so was filed for an order directing the District Commissioner Kamrup M to pass a fresh order on an expeditious basis for taking physical possession of the secured assets. Mortgage with the writ petitioner bank on the basis of the application dated 3/8/2022 under Section 14 of the SARFAESI Act. It is not understood as to how the UCO Bank would be either a necessary or a proper party in the instant proceeding. More so on the basis of an application filed by the borrower mortgager. The Honorable Apex Court has repeatedly held that the borrower mortgager has no right of hearing in an application under Section 14 of the SARFAESI Act, and the issuance of the order for taking physical possession is a mere ministerial act without any adjudicatory process. In other words, no party has the right to agitate its grievances at the stage of entertaining an application under Section 14. Hence, there is no legal or factual basis to impede the UCO Bank if the WPC number so and so filed for such limited relief. And further in paragraph 6, Manoj, we have said that on the other hand, the IA is a gross abuse and misuse of the valuable judicial time, has been filed without any regard to any provision of law, based entirely on mere presumptions of the applicant. The application has
Heard Mr. I.S. Majumdar,
I.S. Majumdar.
Learned Counsel for the petitioner. Stop. Also heard Mr. A. Ganguly, Learned Standing Counsel for Punjab National Bank, and M. Borman, Learned Government Advocate for the State Respondent. Stop. This is an application filed by the applicant stroke respondent number
5.
Respondent number 5 under Order 1, Rule 10 of CPC and under Section 482 of CRPC.
No, my lordship.
482 of CRPC to implement
CPC.
What is implement in your cost?
We want to make the UCO Bank a party in this read actually.
Implement or impleading?
Impleading.
and also Section 482 of CRPC.
How is it,
CPC.
how is it relevant?
Because
Mr. Counsel, please be mindful when you draft a petition.
that's why I'm sorry.
This is not some kind of a letter of administration
Yes,
that can
yes.
be casually drafted and posted. It has been
Okay.
filed in a court of law. You have to be careful as a counsel.
I
Wrong provisions of the law has been quoted. Ki likhila? Of CPC and under Section 482 of CRPC to implead UCO Bank, Guwahati main branch as a respondent in the in WPC number 3161 of 2023. Stop. The case of the applicant stroke respondent number 5 is that the property over which the applicant, over which the writ petitioner, comma, within brackets PNB, is seeking possession under Sarfasi Act 2002 is already mortgaged to UCO Bank by its earlier owner, and thus UCO Bank has the first charge. Stop. In view of the said impediment of UCO Bank has been sought by the respondent in WPC 3161 of 2023 as party respondent. Stop. Mr. A. Ganguly, Learned Counsel for the Learned Standing Counsel, PNB, submits that the instant impleading application is not maintainable inasmuch as the respondent has no right whatsoever for impleading party respondent in a writ proceeding filed by the petitioner. Stop. M.S. Borman, Learned Counsel for the state respondent, similarly submits that the applicant, that the UCO Bank is neither a necessary nor a proper party in the writ proceeding, and as such the impleading application is not maintainable. Stop. I have heard the parties and have perused the materials available on record. Stop. Order 1 Rule 10 of CPC, under which the present interlocutory application has been filed, is reproduced hereunder for ready reference. A. Order to reproduce corridor. Order 1 Rule 10 is suit in name of wrong plaintiff, correct, Mr. Ganguly? How is that applicable here?
No, directly order 1 rule 10 would not be, but the court always in discretion. Actually, the principle, because section 144 of the CPC clearly says that that will not be applicable in the writ proceeding. But the principle sometimes may be applied.
Reading of Order 1 Rule 10 indicates that the court can at any stage of the proceedings, either on an application made by the parties or otherwise, direct impleadment of any person as party who ought to have been joined as plaintiff or defendant, or whose presence before the court is necessary for effective and complete adjudication of the issues involved in the suit. Stop. Where is that paragraph in your affidavit?
Lordship, paragraph 5.
In the present case, the impleadment of UCO Bank is sought on the basis that the property over which the writ petitioner is seeking possession under Surface Act 2002 is already mortgaged to UCO Bank by its earlier owner, and thus UCO Bank has the first charge. Stop. Next paragraph. Assuming without admitting that the same property is the subject matter of mortgage with two different banks, comma, it is for the concerned bank to agitate its rights in respect of mortgage itself. Stop. The applicant appears, the intention of the applicant appears to delay the recovery proceedings by resorting to implead the UCO Bank. Stop. Be that as it may, the presence of UCO Bank is not necessary for effective adjudication of the issues involved in the writ petition. Stop. As such, the impleading application stands rejected.
So the main writ petition may come up for admission.
In the writ petition, in view list for admission next week date aditya. Next week.
So,
Let it be after 2 weeks, my lord. In the meantime, if physical possession is handed over, I can.
Let it come next week. In the you see if you can get the instruction. Otherwise, on that day. Yes. Ms. Aikya?
Wait, Your Lordship. This petition is filed for impeachment of the newly incumbent.
All right.
So kindly
Mr. Barpujari?
I was rather appearing for R1. If Lordship may be pleased to peruse order dated 22/1/24, first in the main condemned petition. Because he has expired by that time.
So
R1 has expired.
So therefore, they are filing an impleading for R1.
In place of R1, the other respondent.
Impleading is for the fresh incumbent to the post R1.
R1, yes, Lordship. Gyarendra Dev Tripathi, the respondent.
All right.
Lordship, another 3 numbers of respondents are there. That is Deputy Commissioner, present Deputy Commissioner, Sumit Satwan, as respondent number 7.
One sec, Mr. Aikya. You are seeking impleadment of 3 incumbents.
4 incumbents.
4 incumbents. Which paragraph have you said it?
Lordship, kindly see the cost title of page number 2.
Yes. All right.
To implead present Commissioner and
Okay,
Secretary.
just hear the order. Heard MS case hai kya?
And they.
And they, Learned Counsel for the petitioner. Stop. Also heard Mr. R. Barpujari, Learned.
My Lord, Counsel, I am appearing for my Lord R1, who has already expired.
Learned Counsel for respondent number 1. Stop. This is an application under Order 1, Rule 10(2) and Section 151 of CPC to implead present Commissioner and Secretary to the Government of Assam Revenue Disaster Management, namely Shri Gyanendra Dev Tripathi, as contemner / respondent number 6 in place of former Commissioner and Secretary to the Government of Assam Revenue Disaster Management, namely Rajesh Prasad within bracket respondent number 1, comma, present Deputy Commissioner in the District Kamrup M, namely Shri Sumit Sathawan IAS, as contemner / respondent number 7 in place of former Deputy Commissioner Kamrup M, Shri Virender Mittal within bracket respondent number 7, comma, present additional Deputy Commissioner Revenue in the District Kamrup within bracket M, namely Sanjeev Dalai, as contemner respondent number 8 in place of former additional Deputy Commissioner Revenue Kamrup M, Navadip Pathak within bracket respondent number 3, comma, present Chief Engineer PWD Road in the district Kamrup M, namely Sanjeev Sham as contemner stroke respondent number 9 in place of former Chief Engineer PWD Roads in the district Kamrup M, Ajit Kumar Kakoti within bracket respondent number 4, comma, present Executive Engineer PWD Road in the district Kamrup M, namely Munindra Chandra Deka as contemner respondent number 10 in place of former Executive Engineer, comma, PWD Road in the district M, Bhupen Sharma respondent number 5 in the contempt case C number 157 of 2018. Stop. It is submitted in the bar that the aforesaid implement is necessitated on the ground that contemner number 1, I. Rajesh Prasad, has expired
on
24/7/2022, and the respondent number 2, 3, 4, and 5, who were holding post in PWD Roads, have in the meantime retired. Stop. In view of the aforesaid, it appears that the implement of the aforesaid incumbents are necessary for effective adjudication of the contempt petition. Stop. Accordingly, the prayer for implement is allowed. ওপৰত যেনেকৈ লিখিছোঁ তেনেকৈ গোটেইকেইটাৰ নাম দি পেলাই is allowed, is ordered বুলি কৰি দিব. Okay, and finally disposed of. In the main case, in the contempt case, let a amended cost title be submitted to the registry for doing the needful. List and issue notice. Correct. Issue notice returnable 3 weeks. List after 3 weeks. On a date to be fixed by the registry of the school. Okay, sir? With ID card acknowledgement within the period of 2 days from today.
Only one aspect of the matter, that contemner number 6, who is now thought to be newly impeached DT Tripathi, he is holding the post of principal secretary, not commissioner and secretary. They have also wrongly mentioned it, because the post of commissioner and secretary is now lying vacant.
So then you inform Ms. Day, when you submit the amended cost title, you ensure you give the proper designation. And Mr. Bhattacharya, can you also give the details to the court master so that I incorporate it in the order correctly?
Only that much, madam.
Just that part. Kalpana, R6.
R6 only, instead of commissioner secretary, principal. That much only, madam.
Instead of commissioner secretary, it shall be?
Principal secretary. And so obliged.
Lordship, in main contempt petition, there is another IA is pending, 2259. That is infractuous, Lordship.
That is for?
Infractuous, Lordship.
Infractuous? Acha, IA 2259
yes.
of 2019. Heard MS so-and-so, also heard Mr. so-and-so. MS so-and-so learned counsel for the petitioner submits that the interlocutory application in the meantime has become infractious. Stop. In view of the aforesaid endorsement made by the learned counsel for the applicant, comma, this interlocutory application stands dismissed as infractious.
Okay.
Yes.
Please, Lordship. This writ petition has been filed by the employees of the National Health Mission for getting the benefit of EPF and employee state insurance.
Benefit under?
Benefit of the EPF, Employees Provident Fund. EPF, Employees Provident Fund. And to register them under the employees.
Why is this matter pending for such a long time?
Department had not filed the reply.
No, counter affidavits are filed way back in 16 and 20. It appears you have not filed any rejoinder.
No, Lordship, kindly peruse the order dated 18/9/2019.
Yes.
Wherein my contention was that the department has said that whose salaries are up to 15,000 had already been given the benefit of the provident fund with effect from 1/4/15. But my query...
NHM, Mr. Gogoi, NHM is respondent number?
Madam 2.
So after this, this order, respondent number 2 has filed an affidavit on 27/1/2020.
Lordship, that's the one.
Correct.
Lordship.
Yes, madam. We have filed a
Have you addressed this issue, Mr. Gogoi?
madam, so far as madam,
There
the
was a
issue
query
regarding
in the order dated 89, there was a query by the court, Lordship, that they have said that we are giving the
15,000.
15 benefit of EPF to the salary holders of 15,000. But my condition was that there are people who are getting more than 15,000, up to 42,000. What about them? The
So what
department
is the answer of
they did not give any reply till date.
Mr. Gogoi? Have you answered to the query?
madam, that was the madam, approval given by the central government.
Correct, Mr. Gogoi. But if,
Beyond that, yes.
you see, Mr. Gogoi, if you see the order of 18/9/2019,
Madam.
it appears that the petitioner has expressed their dissatisfaction of the ceiling of the salary up to rupees 15,000. Correct. So the specific grievance of the petitioner appears to be that there are people who are getting more salaries more than 15,000. Now, what about the ESIC in respect of those category? Now, this is the instruction which was required to be placed by you. Is it
Madam,
not?
the affidavit we have stated, madam, central government has madam, given up till madam, 15,000 only.
No,
I
but
can,
what is the rationale of that? On what basis this has been fixed?
we have annexed one later, madam, this dated madam, 8th of March
I think
2016.
it is appropriate that you get the adequate instruction, because otherwise this court will have to decide
Yes, madam.
whether the ceiling is whether the relevant considerations have been taken or not. Right?
Madam, madam.
Who is appearing for the central government?
Central is not a party.
You are respondent number? Have you filed any affidavit? You are respondent number?
4.
4 has filed. Yes, you filed in fact in 16 only. Have you addressed this issue? You see, both of you cannot keep shifting the burden. Now, it would be appreciated that you will share the burden and come up with a concrete affidavit where you address the issue that is involved in the writ petition. All right.
Madam.
There must be some rationale for fixing 15,000.
Yes, madam.
That must come out.
I appear on behalf of respondent number 6.
Yes, you have also filed an affidavit.
I filed. This affidavit of the allegation given to me just now, I have done to this. But it is a fact that there is a limit of 50,000.
Correct. Now, on what basis that has been fixed?
There is a provision of the act. So I'll have to.
Absolutely. You see, because that is the issue now.
I couldn't get the instruction
The restriction of this court otherwise is known, but that doesn't mean it is immune.
I have tried to obtain instruction over phone whether they are really complying with the provisions of the act. They couldn't give it, so I'll
Yes, all of you, you are, since it appears that you all have already filed your affidavits. Correct. Affidavits have already been filed. Be that as it may, the issue is still not addressed. So you file an appropriate affidavit and address the issue. Yes, you want to say something? For? You have not even filed your affidavit. File your affidavit. You cannot be taking the petitioner by way of a surprise. So whatever objections you have, you put it. No, but you are saying it is not registered.
By merely saying, file the affidavit, then we can address it.
You file your affidavit. It appears that an affidavit in opposition was filed by respondent number 2 pursuant to the direction passed by this court on 18/9/2019.
No, Lordship. That affidavit filed prior to that.
No. Stop. Then you're right. A perusal of the said affidavit in opposition indicates that the query raised by this court by order dated 18/9/2019 is not addressed in this affidavit. Stop. Accordingly, Mr. B. Gogoi, Learned Counsel, appearing on behalf of respondent number 2, seeks 2 weeks' time to file an additional affidavit responding to the query posed by this court earlier by this court. Stop.
With copies to all.
Stop. Further, the respondent number 4, 6 and 5 are also at liberty to file additional affidavit, to clarify the matter if they so desire.
Sir, respondent 6 will have to, my lord, place the legal point, my lord, whether it's just levy still 15,000 or not. That part, if they clarify, then
it's all right. You first file it.
All.
But the understanding is that everybody comes up with their own affidavit. Huh? List after. Did you?
Deep privilege.
Wait, please, Lord. This is a petition seeking a direction to the respondent authorities to hold elections to a village council of the Tiwa Autonomous Council, as mandated by the Tiwa Autonomous Council Act of 1995.
Yes.
As on the last occasion, some instruction was supposed to be given.
My lord, in this matter, now I am facing some practical difficulty, my lord. My lord, what happened in 2022, this WPTBC department has been bifurcated, abolished, and my lord, now tribal affairs is handling this, and they are not a party, my lord. If they are implemented only, then only I can, my lord.
You impede them as a party then. Mr. Ardhor, Learned Standing Council for
Tribal Affairs, my lord.
Tribal Affairs, submits that the Department of Tribal Affairs has been bifurcated from the WPT and BC department, which is the arrayed respondent in the writ proceeding. However, the new department of tribal so-and-so is not a party respondent. He further submits in order to effectively adjudicate the present writ petition, the department of so-and-so is required to be implemented as a party respondent.
Department of Tribal Affairs, claim.
Stop. Mr. Ibor Thakur, Learned Counsel for the petitioner, accordingly seeks 2 weeks' time to file necessary impleading application in the matter. Stop. List after 2 weeks on a date to be fixed by the registry. You want an inquiry committee to be constituted?
Yes, Lordship, because the Lordship can be...
Guidelines for hospital.
Yes, Lordship, IPH
Issue
in India.
seems to be very important, but
Yes, Lordship.
who are you and what is your focus?
Yes, I'm representing my wife.
Aggrieved?
Yes, my wife was pregnant and her first child died. Then with regard to second child, there was complications and she was shifted from one referral to another referral. And as per the IPHS guidelines, there has to be in the district hospital.
Mr. Gogoi, what is your response?
One affidavit has been filed
By
NHM, National Mission Respondent number 2.
NHM. Yes.
But regarding these schemes and all, my lord, it is the state of Assam will have to, my lord, formulate.
Who is appearing for State of Assam? Ms. Borman? Yes. Mr. Upamanyu.
Yes, Lordship, for the health and
You are for health.
Yes, Lordship.
Yes, what is your stand?
Lordship.
It's a 15 matter.
Yes,
You
Lordship.
seem to be unaware.
Lordship.
You have a file or not?
No, Lordship. Lordship, but a short date may be given, Lordship.
Do you have the papers of this writ petition or not? Or are you borrowing it from Mr. Gogoi?
I am borrowing it.
So in that case, you give a copy of the petition because they may not have been there
At that time. Yes, Lordship.
So,
I'll provide.
Mr. Upamanyu, in the meantime, you find
I'll
out
get the
because you see if there are some guidelines required to be framed or if there are guidelines already there, then the same has to be implemented.
Yes, Lordship.
And issue otherwise is important because
Yes.
stakeholders are there,
Yes,
right?
Yes.
All right. In item number 5, Mr. You write N Upamanyu?
D.
D Upamanyu, learned Standing Council Health, seeks 2 weeks time to obtain instruction in the matter as they have been, as the matter pertains to 2015, at which time there was different set of counsel representing the Department of Health. Stop. He for MS D. Ghosh, learned counsel for the petitioner, shall furnish a copy of the writ petition to Mr. So-and-so within the course of the day. Stop. List this matter after 2 weeks. Date the doc. Please have the information. Needless to clarify that the issue involved in the writ petition being serious, comma, the respondents shall positively have the positively file their response by the next date fixed.
Can it be on 7?
All right.
7.
May I please? As per order dated 2/9/19, what is it? Inspector report, further state report was called for.
Which order?
2/9/19.
2/9/19, yes.
2/9/19. Further status report was called for.
That has not been, yes, you have.
No, my lord, because it is a matter. At the time we have instruction, my lord. But what is the present status? I have to take
Mr.
N. Chetia, my lord.
Mr. N. Chetia, learned government advocate for the state respondent, submits that a further time may be given in order to place further, in order to place up-to-date status report. Stop. List on 10 June. Prayer about list. Yes.
Last occasion, Mr. R.K. Dabsudri, he was supposed to file it.
Yes, reconstruct the records.
Yes, my lord.
And file affidavit in
Yes.
opposition.
Yes.
Where is central government? Can you call for? Just wait.
My
Time being. Kawak mati bole koi dio.
This is in respect of land compensation, my lord.
Yes.
Lordship, before my learned senior starts, there is an order passed by this Honorable Court that is dated 11/1/2004.
In this matter?
Lord.
11/1/2024.
24, Lord.
Yes.
Here we have been directed to
Compute
take certain
the
instructions.
entitlement of the petitioner and place it.
Yes, Lord.
Yes, have you done
Accordingly, no, Lordship. Accordingly, we have written a letter to them and they prayed for some time. Thereafter, Lordship, they are, from our respondent side, affidavit in opposition has been filed. The matter, most probably because of that, we are no letter has gone from our end.
It's 19 years, my lord.
Lord, I agree, Lordship,
But
but
this order is of January
let me get
24,
it.
and
lo-
it appears
Lordship-
that an
Lordship,
affidavit in opposition
no,
has
just
been
for a
filed.
moment,
Mr. Roy, it appears
No, I'm not objecting to his time, my lord.
then let's not unnecessarily
Yes,
invest more time in this
Yeah,
matter.
I'm just,
How
because
much
this,
time, Mr. Sharma?
let it be in the last part of June, Lordship. Because no, otherwise I have not afraid, Lordship. The election is there, and the land is voluminous, Lordship.
See, Mr. Sharma, this court is giving you time, but be
I
reasonable
appreciate
also.
it.
This is a matter of 2016,
Lord.
so you know.
No, had it been a small
I'm
land.
sure your good office can get the instructions required. Mr. Sharma, H. Sharma, learned additional senior government advocate, submits that the information sought for by order dated 11/1/2024 is yet to be received. Stop. He produces a communication dated.
From them, Lordship.
Yes, dated. Dated such and such, received from the so and so, seeking further time provide the requisite information. Stop. Yes, you got the date? Give the date.
No, it was earlier, Lordship. Prior to that, thereafter, most probably because of our lacking,
You
Lordship,
had
no
made a
letter.
submission that you have received some letter.
No, Lordship, we have received, that is the 8th of February.
Then you say, Mr. H. Sharma assures
Lordship.
that the requisite information sought by this court earlier by order dated 11/1/2024 shall be positively placed by... Yes, date.
I am praying for last part of June, but
Mr. Roy?
Let it be on, my lord, then 10th June, my lord.
I will try my
By
level.
10th June. Not label best, assurance.
Yes.
By 10th so and so. Stop. In view of the aforesaid assurance made by the learned additional senior government, this court, as a last chance, grants, allows it. Stop.
Otherwise, Lordship may proceed with the available.
Failing which,
Lordship.
this court shall be proceeded in accordance with
Lordship. Much obeyed.
Mr. Sharma, nowadays these copies are available online. That is why we are not directing it to be given to you. But you enclose a copy of this order and
Lordship,
get the
Lordship,
information.
no, Lordship, I learn.
Yes. Yes, you are supposed to file an affidavit in this matter. What has happened?
Lordship, this matter is escape or notice, Lordship. Lordship, let it be fixed next week, Lordship.
You see, these excuses are not good enough. Affidavit was supposed to be filed, and it's an old matter. By now, it ought to have been filed. I understand sometimes a matter can be inadvertently left out, but it's the old matters should be given due priorities. Next week.
Next week.
But the affidavit appears not have been filed.
No, not yet filed.
MS so-and-so, learned...
I'm appearing on behalf of Mr. R.D.
MS so-and-so, learned counsel, appearing on behalf of Mr. R.D. Chaudhary, learned DSGI, assures that the affidavit in opposition in the matter shall be filed within a period of 1 week from today. Stop. List after a week, date of the leader.
The interim order that
Interim, if any, shall continue till the next date of listing.
No, please.
Yeah, please, Your Lordship. I'm appearing on behalf of R.B. Vora, season election court number 1, Lordship, and the past.
Please tell Ms. Bora that there is an order that if BTC does not come up with instructions, this court shall proceed in the matter. Pass over.
11 to 14.
This is for dismissal.
Well, in fact, we all missed the last occasion.
In this matter, my lord, statement has already been made and it is assigned to the requiring department. Person to allocate.
Have you given a copy to Mr. Dubey?
No, yesterday night I have received this.
You have a... Mr. Dubey?
Yes, madam.
Have a look at it.
Madam.
So this is for non-payment of compensation.
Yes. What happened, my lord, in this case, that Silsaku area, they have...
So now you have
we are
received
going to acquire
instruction
it, my
that you will be making the
Yes.
payment because
This
the
is
amount
the
has
estimate.
already been deposited.
Yes. They have initially that land was in their name because of after receipt of premium, my lord, but they did not get that building permission due to it is fall under 2000 Act, 2008 Act, matter. Water bodies they are restricted. So permission was not granted. Accordingly, court government has decided to acquire the land, and this is the estimate. Madam.
Yes, madam. What has happened, Lord? We came before your lordship, Lord, challenging the decision of including our portion of land, Lord. We are a society, housing society, and we were allotted by paying by making payment of premium amount, Lord, and we were not allowed to construct. Now they had included our land under the Guwahati Water Bodies Act, and by that time, Lord, we had entered into an development agreement with the petitioner in item number 12, Lord.
But it has already acquired.
Yes, no, Lord, this has happened, Lord.
Subsequently.
We said, Lord, we can't hold a water body, Lord. So it's better the government takes it And that's how the
Now
entire.
what is to be done?
But so far as our petition is concerned, but let this acquisition proceeding continues. But there are two more.
You are you are in item 11.
Yes, my lord.
And item 11.
My lord, item 12 is by. My lord, we have an agreement with the builder, my lord. There we have filed a writ petition.
In
Affidavit.
item 12, the builder has come. Mr. Majumdar is
Yes.
now for the builder. So what is to be done now? Because it appears that the government has taken a stand of depositing the compensation.
And my lord, item
So
number
are
13.
you all satisfied with this compensation?
13 and 14, Lord, may I indicate first, Lord? These are our members, Lords. They are having some disputes with us. And there are interim orders in those cases, Lord,
For what?
for not to distribute the amount, my Lord, now.
Yes, if we dispose of now, we will those interim
No,
order will stand vacated. But in 13 and 14, it is Mr. Biswas who is there. Why are you
No,
taking the responsibility on your shoulder?
No, I am not taking, Lord, just I am indicating to your Lordship, Lord.
Yes.
In that case, we
All
have
right, he's there.
we have filed
Yes,
our
Mr. Biswas.
stay vacating applications, Lord, in that case, Lord. I will be praying that your Lordship will take it up sometime next week, Lord.
Mr. Majumdar and Mr. Biswas, are you all satisfied with the government's instructions?
We are not informed about this. I came to know just now. I have not, but today he has filed an IA wherein he seeks a vacation of the interim order that was passed in our favor.
That is all right. Now the question is as per this, I think the matter can be disposed of.
If your Lordship direct them to give us a copy so that we go through it, because totally unaware of this.
It's up to them, my lord. Quarrel is
So,
between
Ms.
them.
Burman,
We
you
will
do
be
one
concluding
thing.
the
You
process as
file
per
an
law.
affidavit and let everybody be aware of what has happened.
That will be
Or,
brought on
or you
record
supply
and-
this to all.
My lord, this is pertains to only respondent case in respect of 11, my lord.
Correct, but you see, the
But
land
it
in
is yet
11,
to be concluded, my lord, that process.
the problem is that the
I
land
can
which
supply a
you
copy
are
to them, my lord.
acquiring
No,
in item 11 is now given to the builder who is in item 12, and the association, they are the members. So
Members.
somehow or the other, they all are interested
I
in this
can
land.
give this information
Correct.
to all of them.
Is it
my
correct
lord.
or not?
Yes.
No, I can provide this inspection to all of them, my lord.
You provide it, you'll take your own instructions. M.S. Borman, M. Borman, Learned Government Advocate, submits a copy of the instruction dated 20/5/2024 received in the matter. Stop. A copy of the instruction is directed to be furnished to the respective councils appearing in the writ petitions. Stop. List this matter next week
My Lord.
on so and so date.
But along with our applications being filed, Lord, for certificate.
A copy of the instruction dated 25/2024 is kept on record and marked as X.
Can it be, my lord, either 3rd or 18th, my lord, because I am late by learned additional.
All right,
editor
all
general,
right,
my
all
lord.
right.
Third of June.
Obliged.
Okay.
And Lord, our stay vacating along with our stay vacating.
That will come,
My Lord.
Mr. Dubey. Yeah, fine.
Yes.
All right. In item 11, also add Corriba. It is submitted by Mr. R. Dubey, Learned Counsel for the petitioner, that a stay vacating application has been filed in
Item number 12 and 13.
in WPC 4395 of 2020.
No, Lord, subsequently. 13 and 14, sir.
In WPC 6254 of 2023 and WPC 7355 of 2023. Stop. However, the same is not available on record. Let registry verify and tag the said interlocutory applications along with the writ petitions.
May it please your lordship.
Yes.
On last occasion, your lordship has granted some time to bring the record, lordship.
Yes, records. Miss Udas was there. Ms. Norman, are you aware of this court order?
My lord, in this case, allotted to my
Udas.
senior. No, my senior BJ Talukar. I'll inform him later. Matter will take after some time.
Please wait. Yes, Ms. Bora. Instructions.
It's acknowledged, lordship. Actually, I send the draft affidavit for waiting, lordship.
You have received the instructions?
Yes.
All right, then you file the affidavit.
Immediately
MS RB Bora Learned Standing Council BTC submits that the necessary instructions have been placed in this, have been received in the matter, and accordingly an affidavit in opposition has also been drafted, which is now pending for settlement before the authorities. Stop. She further submits that accordingly list this matter after 2 weeks, dated the date of I so and so, to enable the BTC to file the affidavit in opposition in the matter.
I think, my lord, Mr. K. Gogoi appears, my lord. Some difficulties, my lord, case can be confirmed today, my lord, because he is informed me that, my lord,
it is informed at the bar that Learned Counsel for the petitioner, Mr. K. Gogoi, has some personal difficulty today. Stop. In view of the aforesaid request made on behalf of the Learned Counsel appearing for the petitioner, list this matter. No. Next week or date of the idea.
Please,
yes.
This has been listed after a long time, my lord. Let me get the instruction, my lord.
Yes, Mr. Bora. In fact, today, in all the matters, this is the position. All these matters have come after a considerable long time, and it looks like.
In 2019, I was not the standing counsel of GMDA. Now I have to take the instruction from GMDA.
Mr. S. Bora, Learned Standing Counsel, appearing on behalf of respondent number.
GMC and GMD, my lord. Respondent number 2, 2, and 3.
Mr. S. Bora,
all the rest.
It appears on 19/2/2020 also, you were there.
Yes, Lordship. He has received the notice also.
You have received the
notice.
notice.
For GMC, my lord. For GMC.
Now
it's GMD also. Now,
yes, but what about GMC, Mr. Bora?
GMC, my lord, there is notice, my lord, but in the meantime.
You see, Mr. Bora, this court takes very seriously when a statement is made from the bar. So be mindful when you make a statement, because it will not be a correct statement. I was going to record that. You had earlier accepted notice on behalf of one entity.
GMC.
Correct, but right now you are saying for both, isn't it?
All 3, my lord. GMD also.
What about GMC? You are not appearing for GMC?
GMC also I am appearing, but development is there.
Where is the affidavit for GMC?
But GMC will not come. Development is, there is a development.
You be fair. Yes, what is the
development? He has applied for the regulation of the permission from the GMD. The permit will be given by the GMD, then the NOC will be given by the GMC. That issue I have to get the instruction.
No, Lordship, we have applied for NOC, Lordship, over the same plot of land, but till date, Lordship, since 19, Lordship, till date they have not issued the NOC.
It's very unfortunate that that simple issues are kept pending for such a long time. It is only about giving him the NOC. If there are reasons for which the NOC cannot be given, you state it in an affidavit, and let's finish this matter. Why this matter has to be kept pending for so many years? You see, the litigant is also suffering. He may have a case, he may not have a case. That is a different thing. But he has come to the court with certain expectation, and the duty of this court is to meet with the expectation of the litigants.
I will get that particular instruction, my lord.
It's unfair. It's absolutely unfair for keeping these matters pending for such a long time. It's just a question of issuance of NOC. When can you have it?
Well, after a week.
It appears that the issue involved in this writ petition is as regards non-issuance of NOC. For
building, Lordship.
For constructing the subject residential premises. Stop. Mr. S. Bora, Learned Standing Counsel for GMC and GMDA, assures that the requisite instructions and or an affidavit shall be positively placed /filed before this court by the next date. Stop. List on 10/6 so and so. Mr. Bora, please, you don't have to file a detailed affidavit. Just find out.
Only on that issue, Lordship. If they have issued the NOC, Lordship, everything, that matter became infrastructure.
The Asansol house, he is pending without the NOC. Subsequently, he had applied.
Whatever, you see, Mr. Borda, you are repeatedly admitting the fact that he has applied. Now, if he is applied, then the authorities cannot be sitting over it.
Since 2019, Lord.
That is the whole issue. To find out the reasons why there is no action.
Obliged, obliged.
Yes. Yes.
Please, Your Lordship.
In this matter, I am praying for some accommodation on behalf of the T-NAC senior woman. He is handling the case and he is preparing also the affidavit.
Affidavit is under preparation?
Yes.
Are you sure?
Yes, my lord. Just I talked to.
On the next date, this court need not hear that the affidavit has been sent for vetting. So you please come up with a firm date by which the affidavit will be filed. When?
2 weeks.
B. Bora.
Mr. So-and-so, learned government advocate for the state respondent, submits that the affidavit in opposition is under process, is under preparation, and accordingly seeks some accommodation in the matter. Stop. Prayer is not opposed. List this matter on 11/6/2024 for enabling the respondents to file their affidavit in opposition in the matter. Yes.
Yes, Lordship, here.
CBI.
Yes, sir. See, CBI is also there. We have filed one affidavit, my lord.
Additional affidavit?
Additional affidavit. That is.
Yes. What is the affidavit covers the issue?
Issue means, my lord, that missing of a boy, my lord, that means fact.
Huh.
Now they want a CBI inquiry. This is the subject matter of the petition.
What is the affidavit, in your affidavit, what steps
Steps
have you taken
we have,
till now? Have you indicated?
Yes, we have taken whatever possible, but it is.
The boy is still missing?
Could not find out any clue, my lord. Could not
The
find
boy
out.
is still missing?
Yes,
Missing, yes.
You are referring to the affidavit filed on 5/5? No, on 10th May.
10th.
There is already a direction of the DGP to transfer these two cases to CID.
The CID already transferred. Now this affidavit filed by CID official. Earlier it is registered in the Jalukbari police station. Now transferred to CID. CID constitute a SIT. They make investigation but fail to find out any clue of that point.
Yes, it appears that the investigating officer, despite making all attempts, could not find the missing boy.
Yes, Your Lordship. But as per the status report given by the other side, Your Lordship, one SIT was conducted, Your Lordship, they have stated, but no report was given at the status report, but simply mentioning a SIT was constituted, Your Lordship.
Gogoi,
Lordship.
The affidavit is not... you see, of course the deposition is there, but where are the reports?
Report here not.
Why have they not been enclosed?
That is not enclosed
You
here.
provide the reports.
Yes.
Let us see what has happened, how the reports have been prepared.
Yes, Your Lordship. No report, nothing.
Earlier they
Because you see,
simply making a
it's
statement.
the fact that this boy is still missing.
Yes, admitted fact.
And unnecessarily this court will not direct a CBI inquiry unless and until this court comes to a finding that the inquiring authorities have not done their part properly. There has to be prima facie some satisfaction, correct? The affidavit otherwise indicates that you have done it, but despite that, nothing. But what exactly you have done, that is not spelled out. Is it or not?
Yes. They filed twice status report only.
Same.
Status report.
Where is the status report?
That is their name. Record, my lord. One that is 29th February, another 9/1/24.
9/1/24 and 9/29/2.
But that is January 24.
Yes, yes.
What is the up-to-date status?
Up to the date is only this two reports.
They have said that they have went to a river police station, but only one river police station was searched, whereas there are 6 river police stations.
Please, Mr. Gogoi, can you assist? The inquiry report, just flag it.
The inquiry report only, the status report only.
Where is it? It appears that they are doing their part.
But Your Lordship, after 4 years, the police has transferred the case to the CID, Your Lordship, and in 9 months, Your Lordship.
Now it has been already transferred, and the CID has also thereafter investigated. Correct?
Constituted on SIT.
SIT, which SIT has given this report.
Yes.
But Your Lordship, what SIT has conducted, Your Lordship, the exact report, the accurate report has not been provided, Your Lordship. And Your Lordship, they have said that they have transferred the case to one CID officer, and in 9 months, again the case has been transferred to another CID officer. Only just a shifting of border, this border of shifting has been done by the officers, Your Lordship, but nothing more than that, Your Lordship. And they have said that they have searched one river police, Your Lordship. There are 6 river police stations, Your Lordship, but they have not searched the other river police station, Your Lordship. And one more accused is respondent number 11.
It appears from the status report dated 29/2/2024, placed before this court earlier, that a special investigation team within bracket SIT was constituted by the Commissioner of Police, Guwahati, with a memo number underline kora ase sai lobo, dated 12/6/2019. Stop. Despite the investigation of the subject to cases having been taken over by the SIT, till date the missing persons have not been recovered. One boy?
One boy.
The missing person has not been recovered. Stop. It further appears from the aforesaid status report, including the affidavit in opposition filed on 10/5/2024, that despite efforts being made that necessary efforts have been made in order to recover the missing boy. Stop. Be that as it may, it appears that the boy is still missing. Stop. In view of the above, it is expected that the investigating authorities shall further carry out the investigation expeditiously by looking into all the aspects of the matter and conclude the same as soon as practicable. Stop. List this matter after 2 weeks on a date to be fixed by the registry, on which date up-to-date status report of the investigation shall be placed before this court. Okay? Let's see what happens.
Your Lordship, there were with CCTV footage, there was not recovered, Your Lordship. The CDS was not searched, Your Lordship.
Do you want a date fixed?
The date will be fixed, Your Lordship. Your Lordship, one more respondent, respondent 11 was not interrogated, Your Lordship.
You see, I have already indicated. Let them do their job.
The date will be 13.
13/6.
Oblige, Your Lordship.
24 and 25.
Yes. Electrocution dead.
Pardon, Your Lordship. No. It is a matter pertaining to settlement of a case.
Oh, 25.
24 and 25.
24 and 25. It will become infractious. But the petitioner is not there.
Lordship, the petitioner's counsel has already withdrawn the case. Withdrawn from the appeal. Lordship, in fact, subsequently, there was another petition filed by us in which an order has been passed.
Okay. None appears for the petitioner when the matter is called. Stop. It appears from the office note dated 6/3/2021 that the petitioner, that the learned counsel appearing on behalf of the petitioner has withdrawn from the instant writ petition. However, no new set of counsel has entered appearance on behalf of the petitioner by filing wakalatnama. Stop. It further appears that there has been no representation on behalf of the petitioner since 19/2/2021. Stop. In view, what is your submission?
Lordship, in fact, there was another two writ petitions filed by us after we have got the settlement, and there was.
Are you saying this petition has become infractious?
Lordship, because as per the order dated 10/2/2023, His Honourable Court had directed at para 12. It is needless to say that any amount paid in the meantime is required to be adjusted. It is further held that since the petitioner is continuing in terms of the interim order, he may be allowed to continue, and the settlement which has been given to the petitioner may be continued till completion of the term, unless there are other relevant factors not to do so. Not to we are continuing as on this.
But here the petitioner is Uttam Kumar
Yes,
Das.
Lordship, I am the respondent in this petition.
Mr. M. Das, learned counsel appearing for the private respondent, submits that in view of the order passed by this court in WPC 368 of 2022, 3668 of 2022, filed by the respondent number,
in respondent number 5 in 28.
filed by the private respondent, this writ petition has become infractious. Stop. A copy of the order dated
It is 10/2/2023
is placed on record. In view, and Mr. P. Sharma, learned standing counsel, AFDC, concedes to the aforesaid submission made by the private respondent. Stop. In view of the aforesaid submissions, this writ petition stands dismissed on being infractious. ওপৰত তেওঁলোকৰ এপিয়াৰেঞ্চটো দি দিব নামকেইটা লৈ ল'ব টু ৰিট পিটিশ্যনছ না Electrical inspector report?
Yes, already we have filed, my lord. That's it.
APDCL, who is there?
My lord, I'm on behalf of Mr. J.K. Goswami, Nikon Flip.
APDCL?
My lord.
Yes. What does the report show? The negligence?
No,
elective
report is against us, my lord.
Huh?
Report is against the petitioner, my lord.
So have you filed a reply?
No, my lord.
Where is the report?
Report, my lord. FT, my lord.
Nilmoni
I will respond number 8, my lord.
This is not a case.
I may be allowed to withdraw, my lord, with liberty to, my lord, take appropriate reports, if available.
Item number 26.
26.
Heard Mr.
H.R. Ahmed.
H.R. Ahmed, learned counsel for the petitioner. Stop. Also heard Mr. So-and-so Chetia, learned government advocate
For
the state respondent, and Mr.
J. Borman, on behalf of Mr. J.K. Goswami.
So-and-so learned standing counsel, APDCL. Stop. Mr. H.R. Ahmed submits that in view of the electrical inspector's report. No, I don't think I need to say this. You want a simple withdrawal?
With liberty to take appropriate reports.
Submits that he has received instructions from the petitioner not to press the writ petition and accordingly seeks withdrawal with liberty. Stop. Prayer allowed. Writ petition stands dismissed with, on withdrawal with liberty.
Blessed.
Item number 27. And
Yes,
third.
Mr. Talukdar.
Lordship, item number 15, with highly believe, saying that the petitioners are occupying government hostel.
No, but on the last occasion you were required to place the records. Your affidavit that you are relying is of 8th of 2023, August 23. Is it not, Mr. Talukdar? This order is of 8 May 2024. Yes, Ms. Counsel?
Yes, Lordship.
They have not filed any affidavit.
No, Lordship. On 21/2/2024, there is an order. Your Lordship directed them to produce the entire record, Lordship.
Correct.
That was not produced. So on 8/5, your Lordship again directed.
Yes. Where are the records?
That part, one part of the record is not available. I have received the copy.
What about the remaining part of the record?
Lordship, I am.
Now, what about this missing record?
Missing record is only regarding, my lord.
118 case number.
118 contains, my lord, as it appears, my lord, that the conversion is to the government land. In fact,
But that would be important because your stand is that these are government khas land. On what basis have you said they are government khas land? Where are the records?
In fact, it was government land all along, as it appears from the.
No,
But
Mr.
they will
Talukdar,
this
this court is not concerned with this note. The court had directed you to place the records. So whatever records are there, you place it.
Lordship, I'll
Isn't
take
it?
some more time, Lordship. I'll try one thing.
Mr. B.J. Talukdar, learned additional senior government advocate for the state respondent, submits that he has received instructions from the circle officer Bilasipara Revenue Circle on 16/5/2024. Stop. However, the records sought for by this court by order dated 21/2/2024 is yet to be received from the office. Stop. He accordingly assures that the records called for shall be placed before this court positively on the next date of listing. Stop. List this matter on
After 2 weeks, 3 weeks.
date of the deed. I am not keeping this. In the meantime, if you want to bring it by way of an affidavit, you are at liberty. Respondent is at liberty to bring on record the instruction dated 16/5/2024 by way of an affidavit, additional affidavit.
And deputy of this court.
Don't say are at liberty. In the meantime, shall bring. Mr. Talukdar, I am directing you to bring that on record. I am not saying liberty. So in the meantime, you place that by way of an affidavit because let the petitioner be aware what is happening. This is that bill payment matter?
Yes, madam.
Yes.
In item 27 and 30, my lord, we have filed affidavit, my lord. Amount was, my lord, admitted, my lord. Data has been sent for higher authority for, my lord, sanction, my lord, sanction the amount, my lord.
You have filed affidavit in item number?
27 and 30.
27, okay. Yes, amount is admitted.
Yes, my lord.
These are claims for work done
Yes,
or
my lord.
for
Work
supply?
Done. Work done, my lord.
Under contract?
Yes, madam.
Admitted amount?
Admitted.
Why? Why are you not paying? Where is your affidavit?
Affidavit, my lord.
It's not, the second final person yet. Oh, no.
My lord, my lord, 17/5/24.
Yes, I've got it.
Para 6, my lord, page number 24, my lord.
Non-receipt of fund.
Yes, my lord.
Who's providing fund?
My lord, disaster management, my lord.
Yes.
In this regard, Your Lordship, they have already communicated with the Revenue Department and seeking some time to bring
No,
the
no time shall be given. I'm directing for payment.
Yes.
In all the matters, it's an admitted amount, correct?
In other two matter, my lord, I have not received instruction 28 and 29.
You have received instructions item number 27?
27 and 30, my lord.
And 30. Alright, first 27 of Lekhi Bode. Heard Mrs. K. Devi?
No, D. Angana.
D. Angana. Heard MS D. Angana, Learned Counsel for the petitioner. Stop. Also heard Mr. M. Chetia, Learned Government Advocate for the state respondent.
Respondent number 7.
For the respondent number 7 and MS and Bordeloy, Learned Standing Counsel, Revenue Department. Within bracket, respondent number 2. Anyone for water resources? MS so and so, Learned Standing Counsel, water resource. By filing this petition under Article 226 of the Constitution of India, the writ petitioner is seeking release of the outstanding contractor's bill of the petitioner amounting to rupees 58,61,380 within bracket words against the work orders executed by the petitioner. Stop. The case of the petitioner in brief is that pursuant to work order issued to the petitioner under the Executive Engineer North Lakhimpur WR Division, North Lakhimpur, Assam, comma, the petitioner completed the works allotted to the full satisfaction and within the time. Stop. However, despite of completion of the work, comma, the bills of the petitioner has not been paid, for which the present writ petition had to be filed. Stop. It appears from the affidavit in opposition filed on behalf of the respondent number 7 that the bill of the petitioners have been admitted by the concerned department. Stop. It further appears that due to non-receipt of fund from which department? Fund has to come from whom?
Disaster management.
From the Revenue and Disaster Management Department, comma, the bills of the petitioner are still outstanding. Stop. Paragraph 6 of the paragraph 5 and 6 of the affidavit in opposition dated 17/5/2024 is reproduced hereunder for ready reference. Stop. Reading of the aforesaid averments in the said affidavit in opposition indicates that due to non-availability of fund, the legitimate dues of the petitioner has not yet been paid. Stop. It is unfortunate that despite the petitioner having performed the subject work to the full satisfaction of the respondent way back in, your bill dated, when did you complete the work?
19.
In the year 2019, comma, the bills of the petitioner are still pending. Stop. It is the bounden duty of the state authorities to release the admitted dues of the contractors. Stop. Such deprivation amounts to violation of Article 21 of the Constitution of India. Stop. As such, this court is of the considered view that this writ petition can be directed can be disposed of with the direction to the respondents to release the outstanding dues against the subject bill within a period of 3 months. 3 months from today, within a period of 3 months from the date of receipt of the certified copy of the order. Stop. Let the petitioners furnish a copy of the order to the concerned department. Stop. Disposed of. In item 30, baki to similar thakibo. Affidavit in opposition to filing date was 18/5/24. Or paragraph 2 hobo.
Paragraph 4 and 6.
4 and 6. Paragraph 4 and 6.
In this case, my lord, original amount of 1 crore something was, my lord, already released, my lord. There was a sub-estimate. That amount has not been.
There has been a what estimate?
Original estimate of 1 crore 61
was released.
That has been released, my lord.
Sub-estimate could not be
sub-estimate.
All right, I will I'll put this to pen regot loe disposed of. 27 and 30 is disposed of. 28 and 29, yes.
Yes, my lord, we need some time to take open inspection.
Date may be fixed, Lordship.
If you have these instructions by way of I can place it on Friday, otherwise next week.
Some time is together.
Right. In item 28 and 29, as prayed for by Mr. M. Chetia, Learned Counsel, appearing on behalf of respondent number 7, lists this matter after 2 weeks on a date to be fixed by the registry for filing necessary affidavit in opposition. Needless to clarify that since the issue involved in this writ petition are non-payment of contractual bill to it is expected that the affidavit in opposition shall be positively filed by the next date of listing. Failing which, all right, forget it.
Because we are essentially made party in this case.
All right. Otherwise, I was thinking of imposing interest. Yes, State of Assam, affidavit. Affidavit filed. None. None appears for the petitioner when the matter is called. List this matter after 4 weeks on a date to be fixed.
Affidavit filed.
All right.
Here, affidavit we have filed, my lord.
You have filed?
Yes, they have filed a reply. Can it be, my lord, next week? Come urgency on our part. I have got it.
Is the lordship. Well, along with my reply.
All right. It appears that an affidavit in reply has been filed. It appears no Koba. Mr. B. Sharma, Learned Counsel for the petitioner, submits that an affidavit in reply has been filed when?
Yesterday.
Filed on yesterday, date to Didiba, against the affidavit in opposition filed by the respondent. Stop. However, it appears that the said affidavit in reply is not available in the record. Stop. Let registry verify and place the same on record. List this matter.
28.
Yes, Mr. Gogoi, when?
28 months.
So and so date. Date.
Item 23.
Yes, please. Method pertains to non-issuance of PDS license.
Non-issuance of?
PDS license.
PDS license, Public
Yes,
Distribution System license.
Yes, sir.
Yes, government.
Well, we are awaiting instruction in this matter.
How many more years do you need? Yes, it's a 21 matter. How many notice was issued on 14/6?
My lord.
How many more years?
Last chance.
Mr.
Ji Bokolial.
Mr. So-and-so, learned junior government advocate,
My lord.
seeks further
3
weeks time for filing the necessary return in the matter. Stop. Prayer not opposed. List this matter after 3 weeks on a date to be fixed by the registry to enable the respondents to file their return. Yes. Yes, Ms. Sharma.
Well, we received the records from the Deputy District Commissioner's office.
Yes. This is non-payment of compensation for
Yes.
acquired lands.
Yes.
Why is the compensation not yet paid?
I scanned the record, nothing on record to show that land acquisition proceedings were initiated or an award.
You are
was
aware
passed.
of the latest decision of the Apex Court in the Calcutta Municipal Corporation case? Are you aware? It has recently come.
I'll check it.
Very stringent conditions have been laid down by the Apex Court.
PWD had
as
asked
these
us-
rights which are involved.
Yes.
You see, a land cannot simply be taken without following any procedure and not making any payment of the compensation.
They were given some money for shifting of their houses, but
That
my
is-
lord, that is
Ms. Sharma,
that is neither here nor there.
but unless you come up with the proper instructions, it will be difficult for this code also to proceed. So maybe whatever you find from the record, you can place it fairly by way of an affidavit. If there are no procedures followed, then this court will have to pass appropriate orders. Correct?
Indeed, my lord. But the record is here before the court.
But in that record, according to you,
I don't find.
is not there.
not there. And PWD had taken this land.
Mriganko. Telephone to sir, Kolkata Municipal Corporation or the Supreme Court of decisions. So, MS Sharma, number one, according to you, this is the land is admittedly taken by PWD.
Yes, Malab. That is.
But
there.
The records reveals no procedure for acquisition under which act, under any provision of law is taken.
Yes, Malab. The act
Correct.
is also not known.
And also no compensation.
No compensation.
Except something you have mentioned.
Except payment for shifting of their houses on their own land. Policy sums like few thousands of rupees. Although in 1976. Good.
In that case, what is to be done?
But nice. Well, the LA case LA case fully আছে কিন্তু procedure to কোটা so I have the entire record
You see, Ms. Sharma, if it appears that no procedure have been followed. Now, in that case, the entire action of acquiring is illegal, correct? So, resultantly, what is the effective order can be given? Can this land be directed to be returned back with some compensation? Yes, Mr. Gogo, you can assist this court directly. The records are in front of MS Sharma. She has already verified. No, but what LA proceeding? Where are the records of that proceeding?
Case number 2976 is here, but the procedure I don't find it. Yes, madam. In this set of records, that is the fact.
Then we'll grant you some more time. In the meantime, what is that LA case?
29 of 1976.
LA case 29 of
1976.
1976. Stop. MS S. Sharma, Learned Counsel for the Learned Government Advocate for the state respondent, submits that the records reveals that that no procedure for submits no materials to indicate that the land of the petitioner has been acquired following due procedure of law. Stop. However,
from the record today.
However, she submits that it appears that an LA case of 29 of 1976 appears to have been registered. However, the records of the said case is not available. Stop. Let the records of LA case 29 of 1976 be produced on the next date of listing. Stop. List on 14/6. Sharma, in this decision, it has been clearly laid down that the right to notice, right to be heard, right to a reasoned decision, the duty to acquire only for public purpose, the right of restitution or fair compensation, the right to an efficient and expeditious process, and the right of conclusion. This all has to be there. It has been clearly laid down. This is the latest decision. Anyway, you download the copy and have a look at it.
I will.
It's Kolkata Municipal Corporation.
That's the party name, my lord?
Yes.
Apply.
Decision to require. Yes.
My lord, what had happened in this case is that there are two writ petitions. Now, my lord, one writ petition is listed in court number 13, and this is the second writ petition which is listed here. In fact, my lord, this writ petition pertains to issuance of a law.
So I shall direct this to be listed along with that.
Absolutely, my lord. But the other writ petition is yet to read. So we do not
That's
know.
all
which
right. Whenever it comes.
Absolutely.
It is submitted that a connected writ the connected writ petition, i.e. WPC.
WPC 7497.
7497
Stroke
of
2022
is listed before another coordinate bench of this court today. Stop. Let this matter be listed along with no, not today. On the next date of listing.
I'll mention the date in that time. In the meantime, if they want to file an affidavit, they may file.
In this case,
all right,
Mr.
Biswas, you have made a submission. This to be taken up with that now. That will follow. Yes.
May I please, Lordship? Lordship, pursuant to the Honorable Court Order 18-1-2023, my lord, joint verification was done, my lord. My lord,
Property damage. What is this? Compensation for property damage.
my lord, land.
You do not know what your case is, Mr. Counsel.
Respondent 3 has filed my affidavit, my lord. My lord, verification was done, my lord. My lord, on that basis, my lord, I have no objection if my lord, the land measured up to my 40 feet, middle point of the land, my lord.
Mr. Counsel, I'm sorry, I could not appreciate the submission that you have made. You are all right with the affidavit that has been filed?
My lord.
So, in what line you want this case to be disposed of?
My lord, as per number 3, my lord, they filed affidavit, my lord, and
Lordship, may I
yes, yes.
Can it be taken in some other date, Lordship?
Why?
That I could not trace out my the file, Lordship. Those the affidavit is there. Any next date?
Well, you have a look at the affidavit. He wants it to be disposed in the line of the affidavit, so I shall take it up in some time. Just have a look at it. After 2-3 matters, when you are ready, Mr. Handick, please inform the
Lordship.
Wait for some time. Ms. Bottler, please have a look if it can be disposed of.
37 and 38.
Please, Lordship. Lordship, kindly pass over the matter only for the time being, Lordship.
All right.
Oblige, Lordship.
39. 39.
None appears for the petitioner when the matter is called. List after 4 weeks and a date to be fixed by the registry. In 39.
They are challenging that eviction notice, and the Honorable Court was directed.
Which matter are you submitting?
13-9. Mr. Nath was there.
Yes, but last occasion also there was time sought on behalf of Mr. N. Nath. Anyway, no one is represented today. Yes. Police protection.
Police protection, my lord.
Why?
Affidavit is yet to be filed. My lord, he is basically a social activist, and he involved himself in various operations. He helped the police also, and
But
he was
for all this, I think there is some procedure, some review meetings and all that is required, right? Threat perception.
Affidavit has been prepared, my lord, 10 for fitting, my lord, will file, my lord.
Because otherwise it would be a sad state of affairs if the court is made a medium for providing police protection. These are matters which should be sorted outside.
True, my lord, but in appropriate cases.
Anyway, yes, you have your instructions.
Already we have received instruction, my lord.
What is your instruction? Any threat perception?
There is no threat perception, my lord. Even, my lord.
Sure. If there is no threat perception, what right, Mr. Das?
How the assessment has been made and what is the background of the assessment, my lord? That
This court will not go into that assessment made by the police authorities.
I understand, my lord, but the thing is that, my lord, that
In fact, my lord, case was, my lord, search sheet was filed against the petitioner in another case.
There was a cross case, my lord. The petitioner was brutally attacked in one incident. That the photographs and the other things I have also annexed in the petition.
Anyway,
he
you
was
filed it by way of an affidavit. You have no case, Mr. Das. Sorry.
I'll try to pursue.
Anyway,
I'll try to.
Item Likhiba. Mr. M. Chetia, learned government advocate, submits that he has received para-wise comments and accordingly seeks 2 weeks' time to place the same by way of an affidavit. Stop. Prayer is allowed. List after 2 weeks on a date to be fixed by the registration.
Deeply.
Item 40 days.
Supplementary admission item 57.
Order to Asanikit. I've already passed the order. Repetition stands allowed. Yes, Mr. Borwa. So how much time do you need?
3 months.
3 months. So I'll dispose it of?
Yes, my lord. But subject to, my lord, actually we are entitled to get interest, my lord. As per law, they will get interest, my lord.
In fact, Mr. Mohanto, I am quite inclined to give you interest, but
yes,
you see, be happy with what you have got.
Yes, I got the indication.
Like, if it was a case where they had withheld the money without any reasons, certainly this court would have granted you interest. But you see, availability of funds.
My lord, I leave it.
This is from item 57 to?
No, 58 to...
Sorry, 58 to 66.
62.
Huh?
Our 5 matter we are representing 62.
No, ultimately, oh sorry, till 62.
58, 59, 60, 61, 62.
Earlier also, the other day also you had referred to the affidavit in opposition.
Yes.
That is filed in all the cases.
Yes. No. In one case that we cover all the cases. Because the inquiry was made in respect of all entire, my lord.
And these amounts are in respect of what, Mr. Mohanto?
My lord, supply of relief material. Supply of relief material during flood, my lord.
Supply of
relief material.
Relief material during flood.
During flood, my lord.
In item first, the 58 to Lakhasana. Heard Mr. T.J. Mohanto, learned senior counsel, assisted by Mr. R. Islam, learned counsel for the petitioners. Stop. Also heard Mr. A. Bhattacharya, learned standing counsel, revenue and disaster management. Stop. Anybody else? Mr. M. Chetia for state respondent, learned government counsel for state respondent. Anybody else? M. Chetia or Mr. Handik? You sort it out. By filing this petition under Article 226 of the Constitution of India, the writ petitioner is seeking release of the unpaid supply bills of the petitioner amounting to rupees 1,03,10227.16. Stop. The case in brief is that pursuant to an advertisement for supplying of relief goods for distribution amongst the flood, erosion and other natural calamities affected people of South Salmara Mankachar district, comma, the petitioner submitted his quotation and the same was accepted by the respondent authorities. Stop. Accordingly, the petitioner supplied government relief. Accordingly, the petitioner supplied relief materials to the satisfaction of the respondent authority. Stop. Despite of such supply, the bills of the respondent authorities, bill dated, any dated is there, or there are two, several bills?
Several dates, my lord, very difficult.
Bill dated, despite non-payment of dues, comma, sorry, Bhargav, more flow to bhangi gol, last ki likhila. Has till date not been released. Stop. Accordingly, the writ petition has been filed. Attention of this court has been drawn to the affidavit in opposition filed on behalf of respondent number 2 and 3 pursuant to order passed by this court on 27/9/2023 and 9/4/2023. Stop. Which is that paragraph?
Paragraph 5.
Paragraph 5. Paragraph 5 and 6.
Paragraph 5, 6 and 7 is the relevant, my lord.
Paragraph 5, 6, 7 of the said affidavit is reproduced hereunder for ready reference.
And 8, paragraph 8 is the finding of the inquiry, latest inquiry.
Aru 8 2 koi dia. Moi at mark koi disu running page 145 to 147. Huh? We pai jaba. Reading of the aforesaid averments indicates that a committee was constituted to scrutinize the report received from the CF Vigilance Cell in relation with the bill submitted by the petitioners. Stop. It appears that the said committee has held that the
Para 8 they have stated, madam.
Yes.
Para 8.
Yes, I am reading. That the petitioners have supplied the relief materials to the flood affected persons as per to the satisfaction of the respondent authority. Stop. It further appears, not further appears, this matter upon being called on 21/5/2024, this court, after noting the aforesaid paragraphs, sought instruction from Mr. A. Bhattacharya, sought instruction from the Revenue Department as regard the time frame within which the aforesaid dues can be released to the petitioners. Stop. Today, when the matter has been called, an instruction dated 22/5/2024 has been placed before this court, issued by the Joint Secretary to the Government of Assam Revenue and DM Department, dated 22/5/2024, indicating that the bills of the petitioners shall be released within a period of 3 months' time. Stop. Stop. It is regrettable that despite the petitioners having supplied the relief materials way back in the year 2017,
16, 17. Yes.
the bills of the petitioner has not been paid till date. Non-release of the legitimate dues of the petitioner amounts to violation of Article 21 of the Constitution of India. Stop. Be that as it may, in view of the consensus made by the Department of Revenue, this court is not further going into the matter and is of the considered view that in view of the aforesaid endorsement stroke consensus, this writ petition can be disposed of with the direction to the respondent authorities to release the outstanding dues of the petitioner within a period of 3 months from the date of receipt of the certified copy of the order. Stop. Needless to clarify that if failing release of the with the observation and direction, this writ petition stands disposed of. Yes, Mr. Mahanta?
My lord, that will be covered all the judgment, but amount are different.
Correct.
Amounts
That
are
is why...
amount, my lord, I can give a list, my lord. You will not it.
All right. You give
name
it
of
to
the
court
contact for
master.
difference and
Just give those...
my lord, according to my lord.
Did I give prayer or then I'm mentioning the amount in the prayer, or should I not mention?
So they will pay according to their bills.
That is why I said...
Yes, according to our bills, my lord. Yes.
No. Should I make it a common order? Will it...
Same transaction, my lord. They are same issue, my lord.
I like it to me a separate order, yeah. Because you see, these common orders in these cases
Yes,
sometimes create
Some
confusion.
yes, my lord.
Yes. So you just give me
My
that
lord,
list.
that's how I
That
that bill that supplied in the year 16-17, my lord.
16-17. Last subject question.
Bill supplied this.
16. All right. Disposed of.
The compensation does not arise. Paragraph number 9 and 10 is clearly.
Paragraph number
9 and 10 of my affidavit, Lord. Affidavit filed by as per number 3.
3, Deputy Commissioner.
It is filed by my Lord that additional Lord, Deputy Commissioner.
9.
Paragraph number 9 and 10, Lord.
Stop. Item 36, huh? Heard Mr.
HP Neog.
HP
Neog.
Neog, Learned Counsel for the petitioner. Stop. Also heard Mr. J. Hendick, Learned Government Counsel for the state respondent. Anybody else?
PWD.
Gogoi was appear earlier.
Mr. So-and-so, Standing Counsel PWD. Revenue is also there.
Okay.
Standing Counsel Revenue. You can give the name, whoever is there. By filing this petition under Article 226 of the Constitution of India, the writ petitioner is seeking inter alia direction for compensation to the petitioner for damaging the land of the petitioner after conducting a joint verification over the land. Stop. The case of the petitioner is that the respondents have acquired the land of the petitioner without following due process of law. Stop. Accordingly, Accordingly, the instant petition has been filed seeking compensation thereof. Notice of this court has been drawn to the affidavit in opposition filed on behalf of the respondent number 3, I, the Deputy Commissioner Dhemaji, Assam. Stop. Paragraph 9, 10 of the said affidavit is reproduced hereunder for ready reference. Page 69 on. Reading of the aforesaid averments manifestly indicates that no length of the petitioner has been acquired. Stop. Next para. That being so, this writ petition fails. Accordingly, the writ petition stands dismissed. It took Imam 36. Disposed of. Next,
Met with the Lordship. In this case, Lordship, my father was the owner of 1 katha of land, Lordship, by purchase. And that 1 katha of land was, Lordship, earlier he purchased 1 bigha of land. After that, from that land, Lordship, Railway Authority acquisition, and thereafter 1 katha remains, Lordship. So, from that 1 katha, Lordship, the acquisition process was initiated and award was awarded, Lordship. When I came to know that award amount, from that award amount, I came to know that only half katha of land was accessed, but in fact, the entire 1 katha land was taken by the acquisition authority. So immediately I filed an application, Lordship, that is the annexure. Annexure 1 is my patta, Annexure 2 is the revenue we paid for that amount.
Compensation not given.
Compensation we have received with objection, but Lordship, after...
No, what is your grievance here?
Lordship, in fact, they have acquisition only half katha of land, but in physical possession was taken over the entire 1 katha. So for that,
what is the stand of the government?
Our stand is that, Lordship, we have taken 10.42537 letters. 10.42537. 42537 letters, for which the compensation amount of rupees 6,35,000. 6,35,959
is given.
Just paid to the petitioner.
So, and this you accept?
That was accepted.
Your further grievance is that further land is under the possession.
Lordship.
Now, how will this court determine that issue?
Lordship. In Lordship, affidavit in opposition filed by respondent number 5 in page 29, para 7.
Affidavit of?
Respondent number 5.
That is our affidavit, Lordship. Filed by Bhargav Kolika, Lordship, Dishik, Deputy Commissioner.
Para 7, Lordship, that with regard to the averments made in paragraph...
Just one second. I have the reply to R5, but where is the AO of R5?
Running page 29, maybe, Lordship.
Yes, you are right. Yes.
Para 7, Lordship.
Yes.
That with regard to the averments made in paragraph number 6 of the writ petition...
Fan baki bata diya sir. Listen, the body bunyan. Yes.
That with regard to the averments made in paragraph number 6 of the writ petition, the deponent begs to state that, as reported by Circle Officer Boitamari Revenue Circle by letter dated 14/3/2022, there is a mismatch discrepancy in respect of area of land and the concerned dark. So they admitted, Lordship, there is a mismatch and discrepancy in the concerned dark, Lordship. In the Cheetah copy, the dark number 256 covers an area of...
Can this matter be disposed of with a direction to make an inquiry? And if in the inquiry it is found that there is more length than 10.42537 lecha is under the possession of the government, then appropriate.
Then Lordship, if the excess land is
is under occupation.
Yes, Lordship. In that case, Lordship, we will write a letter to NHIDCL so that the extra amount, Lordship, that will be
correct.
Proper measurement.
Let an inquiry be made. Because unless an inquiry is made, you see, they have some. They've come up with that particular.
I have also seen, Lordship. That's because they are claiming 1 katha, but from our verification map.
According to you, total how much land has been?
1 katha.
1 katha, Lordship.
All right. Heard Ms. R. Chaudhary, Learned Counsel for the petitioner. Stop. Also heard Mr. H. Sharma, Learned Additional Senior Government Advocate for the State Respondent, and Ms. N. Bordoloy, Learned Standing Counsel Revenue Department. Yes? And Mr. R.K. Talukdar, Learned Counsel for the National NHIDCL. Standing Counsel NHIDCL. Stop. By filing this petition under Article 226 of the Constitution of India, the writ petitioner is seeking compensation for 1 katha of land covered by dag number 256, patta number 117, which was acquired by the respondents.
Yes.
Stop. The specific grievance of the petitioner is that though the respondents have acquired 1 katha of the petitioner's subject land, however, compensation has only been given in respect of 10.42537 lecha. Stop. Accordingly, the present petition has been filed. Stop. Mr. H. Sharma, Learned Additional Senior Government Advocate for the State Respondent, submits that compensation has been given in respect of 10.42537 lecha. Only as according to records available, the according to records available, the said land of the petitioner was acquired. Stop. Be that as it may, it appears. Attention of this court is also drawn to paragraph 7 of the affidavit in opposition filed on behalf of respondent number 5, which reads as hereunder. Para 7 to D4, page 29. Okay. It appears that the issue involved in this writ petition is as regards to the compensation for the remaining portion of land which is alleged to have been acquired by the respondent. Stop. In view of the aforesaid, this court is of the considered view that this writ petition can be disposed of with a direction to the respondent, respondent number 5 to cause an inquiry into the matter, specifically as regards how much land of the petitioner has been acquired and is in the occupation / possession of the respondent. Stop. In the event it comes out, in the event it is found that excess land of the petitioner is under the occupation of the respondent NHIDCL, compensation in accordance with law shall be made to the petitioner within a period of 2 months from the date of the submission of the.
That will take some time.
All right.
because
In accordance with law. Stop. Needless to clarify that the entire exercise shall be carried out within a period of 6 months from the date of receipt of certified copy of the order. Stop. With the aforesaid direction observation, this writ petition stands disposed of.
Lordship, may I only add one thing. We have received compensation in regard to land, but no Jirat compensation for.
I'm not saying all that. You have specifically made a case that for
that prayer is not there.
Yes.
Also.
No. Let an inquiry to that effect be made. If excess length from beyond 10 lecha odd is there, you will get your compensation.
Lordship,
correct?
I'm
Mr. Sharma, that is the case.
That is the case.
Sorry, my lord, at the last occasion I missed the matter. So, my lord, the IA will have filed for amendment of the writ petition. Simple fact is that, my lord,
Have you submitted amended cost title and all that? You have filed an amended writ petition?
No, I am for praying for amendment.
You are praying for amendment?
For amendment. I am praying for amendment.
IA is?
IA, my lord, 3715.
So? Yes, Ms. Sharma, you are appearing?
Yes, Lordship. Lordship, this cannot be amended because that is their prayer that they should be allowed to live in that railway plot of land up to 31/12/2023. That is their prayer in the writ petition. So that prayer, Lordship, on the basis of the writ petition.
Ms. Sharma, what is the amendment sought?
They want more time, I think so.
No. What is the amendment that they have sought?
That amendment for deletion of that because.
Deletion of what?
That prayer.
Deletion of a prayer?
No, and to challenging a letter they have issued.
You want to delete a prayer and
amend
and
by
further
challenge a letter issued by them.
Incorporate a new prayer.
New prayer.
How can that be done by way of an amendment? You want to withdraw, you withdraw and file a fresh writ petition?
Because they, during the pendency, they have issued the letter.
Very well, then there is a change in the cause of action.
Only one prayer, my lord, because that is the.
Sorry, you want to withdraw, this court will grant you with liberty.
Then, my lord, withdraw with liberty.
In item 64.
But Lordship, I may kindly see that they are enjoying a stay.
That's all right, Ms. Sharma. If he wants to file a fresh
Then
petition,
interim order has to be vacated.
Ms. Sharma, if they are withdrawing, do you think that interim order will continue?
That may be.
Please don't unnecessarily make submissions. Heard Mr. S. Nath, Learned Counsel for the petitioner. Stop. Also heard MSB Sharma, Learned DYSGI.
CGC.
Learned CGC. Standing Counsel CGC. Stop. Mr. S. Nath, Learned Counsel for the petitioner, seeks withdrawal of the writ petition with liberty to file a fresh petition if need be, in view of certain development that has arisen post filing the writ petition. Stop. Prayer is allowed. Writ petition stand dismissed with liberty. Stop. Interim orders passed earlier shall accordingly stand vacated.
With liberty to express.
IA, accordingly, pending IAs all stands dismissed. Dismissed. Huh?
All the 64, 65, 60.
All of them.
All of same.
So same order. Common
Repetition number.
All pending IAs and all 64 to 68. 66. With liberty.
So lot of repetitions also in view of this order in the IA lot.
I'm sorry, my lord, in the other court.
Yes.
This matter, your lordship, the other day, your lordship almost just at the last end of that argument, my lord. Then your lordship is today, my lord. That is what page 65.
Why? This matter was already admitted.
No, admitted, my lord, your lordship, for disposal the other day, your lordship had it. Then your lordship, because
You
of
should have
sorry,
come for hearing then.
hearing it will take, my lord, normally admission hearing, but in the admission.
It's already admitted.
No, admitted, my lord, but the admission stage.
I'm fixing it for hearing. Tuesday?
My lord, only hearing your lordship normally.
Tuesday is a
Tuesday
hearing
and
date.
Tuesday.
All right. It appears that this matter has been wrongly listed in the admission column. Stop. List this matter for hearing on Tuesday.
28.
In the hearing column.
Interim order.
Interim orders passed earlier shall continue till the next date of listing.
All right. All right.
37, 38, Madam. Yes, Mr. Bhattakur, case diary.
No, my lord, in this case already my lord, charge sheet submitted. My lord. Petitioner is in jail. My lord.
All right, then you appear.
Yes, ma'am.
All right. Charge sheet number.
Charge sheet number, my lord.
Please give it.
29/24, dated 31/3/24.
Information court.
Court by CGM Kamrup Metro.
CGM Kamrup Metro. How many days? 10 days? 10 days. Disposed of.
42 case diary received, my lord, but not updated. Statement of the petitioner is not available in the case diary.
Let up-to-date case diary be produced on the next date. List on
7th of June.
7/6/2024. Interim passed earlier shall continue till the next date of listing.
7.
Yes.
Regarding 43, I am actually my lord. I have not gone to the LCR, my lord. Unnecessarily, my lord. I obstructed your lordship, my lord, while dictating the order.
So there is no incriminating materials?
Incriminating material is there, my lord.
Against the petitioner?
Yes, against him, my lord, because there are, I have taken the statement of the witnesses. 3 of the witnesses named the present petitioner.
So the petitioner has been named?
Yes, my lord. And my lord, proclamation and attachment also issued against the present
3 witnesses have named?
Yes, my lord. And in case, my lord, PNA also issued, and my lord, I have trademarked in the LCR, my lord, also executed, my lord. PNA executed proclamation, my lord, affixed in his, therefore, my lord, after issuing PNA, my lord, anticipated this is not a fit case for granting.
Proclamation of arrest has been issued?
Yes, my lord, PNA, I have trademarked in the LCR, my lord. It is also executed, my lord.
Yeah, latex to API reported trial court, my lord.
This was earlier rejected by this court or similar FIR?
Regarding some other persons,
my lord, after submission of this charge sheet, my lord, all of the co-accused, my lord, Muzammil Haq, he appeared before this court, my lord, and he has been convicted. While only the PA is paid, my lord. And now he is appearing, my lord. My humble submission before your lordship, my lord, as the charge sheet has already been submitted,
all right.
Investigation has been completed, my lord. They will appear, my lord.
So that's already already proclamation of arrest has been issued against you, and your name is there. Sorry. Heard Mr. M. Islam.
S. Islam.
S. Islam, learned counsel for the accused petitioner. Stop. Also heard Mr. P. Bhattakur, learned APP for the state respondent. Stop. This is an application under section 438 of CRPC for granting the privilege of pre-arrest bail to the petitioners, i.e. Anwar Hussain, Ashraful Haq, who are apprehending arrest in connection with PRC case number 2306 of 2023, arising out of Kachumara PS case number 23 of 2023, within bracket GR case number 517 of 2023. Stop. Next part. The case of the prosecution in brief is that on 29/3/2023 at about 10 am, while one Hanif Ali was ploughing in his own ancestral land at Lakhipur Char, the FIR named accused number 1, who was trying to take possessions of the said land, came along with 30 to 40 other persons armed with dangerous weapons. Stop. The accused number 1 asked the Gaubura, i.e. the informant's brother, to distribute the land, and since he did not do so, the accused number 1 along with the remaining accused persons attacked on his neck and head with sharp weapons, for which he got seriously injured and fell down on the ground. Stop. The informant is alleged to have also been attacked. Stop. Accordingly, a case was registered. Mr. S. Islam,
yes,
learned counsel for the petitioner, submits that the petitioners are totally innocent and has been wrongly implicated in the matter. Stop.
Petition number 2, my lord, is a minor, my lord.
He further submits that the petitioner number 2 is a minor.
Yes.
Stop.
At the time of incident, my lord, he was not at home, my lord.
Mr. P. Borthakur, learned additional APP, on the other hand, opposes the prayer for bail. Stop. LTR.
Please, my lord, the petition number 2
He submits that the scanned copy of the case records of PRC, case number 2306 of 2023, indicates that the statements of the witnesses have been recorded by
the IO, my lord.
By the investigating officer, comma, out of which from three witnesses' statement, it appears that the petitioners were involved in the offence alleged. Stop. He further submits proclamation of arrest has been issued by the trial court. He further submits that in the meantime the trial court has already issued proclamation of arrest against the petitioners. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears from the statement of three witnesses recorded by the investigating officer under 161 CRPC that the petitioners are involved in the offence alleged. Stop. It further appears that proclamation of arrest has been issued by the trial court against the petitioners. It further appears that the petitioners are absconding and despite attempt to execute the order of attachment, against the petitioners, the same could not be carried out in view of the fact that there are no property of the petitioners located. Stop. It is in fact because of which NBWA was issued. Correct?
Yes. After NBWA, that proclamation issued.
Stop. Considering the entirety of the matter, this court is of the considered view that the petitioner has failed to make out a case for grant of anticipatory bail at this bail. Accordingly, the prayer for anticipatory bail stands rejected. Yes, sorry. Return, this is not, is it required to be returned, the LCR?
No, it can be. Hello, item number 44, my lord. Just now I have received the case. The petitioner is in interim, my lord. This matter may kindly fix on, my lord, on 28th of May.
44?
44, my lord. Just now I have received the case.
List again on?
On 28th, my lord. He is in interim.
Interim, if any, shall continue till the next date of listing.
This matter may be taken up at 2 p.m. Chief Advocate D. Sukya will appear in this.
Lordship, in this matter, contender number 3 had filed their affidavit in opposition and we want to file our reply. Lordship, 2 weeks time.
So, my lord,
all right, let them file the reply. Your name?
Miss B. Devi, Lordship.
Miss B. Devi, learned counsel for the petitioner, seeks time to file affidavit in reply against the affidavit in opposition filed by the contender respondent number 3.
Three had filed very recently.
Three already we have filed long time.
Against which respondent you want to file?
Well, we have filed respondent number 1 and 3.
Respondent number 1 I have filed recently.
Here received.
For against one. Prayer is allowed. List on.
Respondent number 1, Lordship.
Yes, I have corrected. List on.
After 2 weeks on any date.
List after no. This contempt case is of 2014. List on. Give a date.
I think 46.
After 2 weeks.
Yes, 12 June.
Oblate.
Yes, Mr. Borapujari.
Lordship, may be pleased to peruse my lord's last order. My lord, against the order passed by the writ court, the state of Assam and other authorities had preferred a writ appeal. Eventually, that was dismissed, and it took a prolonged time, my lord, to dispose of that, my lord, for disposal of that writ appeal. Now, my lord, I have specific instructions that in the meantime, all the incumbents who have been arraigned as contempt or respondents, they have retired, my lord, some has expired, and my lord, some are no longer.
Mr. R. Borapujari, Learned Counsel, for the respondent number 1 submits that all the incumbents of the post held by the respondents have in the meantime retired. Stop. Let your name?
R.B.S. Burwa.
Let the Mr. R. Bejbora, Learned Counsel for the petitioner, shall obtain instruction in this regard and do the needful. List after. How much time do you need?
2 weeks.
Have you understood what is to be done?
Yes, ma'am.
After 2 weeks on a date to be fixed by the registry.
Lord, may kindly record I am appealing for R2 and 3, my lord.
1, 2, 3 or 2,
No,
3?
only 2 and 3, my lord.
Bless, ma'am.
Thank you, sir. 47 of the sign is some kind of I have received it. Going to file it.
Mr. J. Handik, learned government advocate for the state respondent, submits that he has received the instructions in the matter and accordingly seeks 2 weeks time for filing return. Prayer allowed. List
When
after.
appearing for respondent number 1 and 2, I have filed the
List
affidavit today.
after 2 weeks on a date to be fixed by the registry. Instructions.
Lord, if may kindly peruse the last order, my lord.
Yes.
My lord, we have duly complied with, my lord, and the compliance letter lordship will find at marked as S.
Complied?
My lord, I have taken instructions, my lord, because this pertains to demarcation of more than 2,000 bighas of land, my lord. They've started it post-election. Election in the district of Lakhimpur.
But they have started.
They've started, but it is not yet completed, my lord. So, my lord, my prayer would be, my lord, if your lordship post it after maybe 2 or 3 months, my lord.
Where is that order against which this...
my lord, the order your lordship will find at the operative part, my contempt petition, page number 14, accordingly, the operative part.
Page number 14.
14. Demarcation of a grazing land because there were some encroachment. Accordingly, this writ petition.
It was directed to complete the work of demarcation within 6 months. That was but now it has started.
Now that report which lordship will find at flag F. Here, my lord, I am.
Yes, Mr. Warpujari.
Here, lordship may kindly peruse, my lord. Basically, the report's direction was to carry out a factual exercise because that part and parcel of land is a huge area. My lord, it is situated in the river bank and some portions are within the river itself. Lordship is well aware of the phenomenon called, my lord, alluvion and diluvion. Sometimes, my lord, the lands creep up. Then again, my lord, during
That's all right. You have started the demarcation.
My lord, but my communication, that communication says that everything is complete.
But
if a copy is, I'm not served with a copy of that.
I will
give him a copy. Let him have a.
I will find a copy, my lord. Lordship will post this after at least 4 weeks, my lord.
No.
Because
4 weeks for what?
No, they will have to take the instruction and my
You
lord.
need 4 weeks to consult with your
No, my
client.
lord.
No, I can consult. I have
one
my.
other aspect of the matter, my lord. I have
Mr. Borpujari, this court is concerned only with one aspect of the matter. That is whether the order of this court has been complied or not complied.
Now
Simple and short.
Yes. Now I have, my lord, placed
have
material
started-
on court that it has been complied, and I am representing our
Very
one.
well. Now let him obtain instructions from his client.
They have started, but they are yet to comply with the entire demarcation.
Then, my lord, they will have to file an affidavit, my lord, with all facts.
Provided we are
But
given a copy.
You have not served you have not furnished the communication dated 3rd April 2024 to the
I
other
will.
side. Mr. R. Borpujari, learned counsel, appearing on behalf of the alleged contemner numbers 1, 2, and 3, by drawing the attention of this court to the communication dated 3/4/2024, submits that the subject demarcation as directed by this court has been completed.
Completed, and it has been complied.
However, Mr. M. Biswas, learned counsel for the petitioner, submits that as per instruction received, the process of demarcation has been started, but the same has not yet been completed. Stop. He further submits that a copy of the communication dated 3/4/2024, earlier submitted before this court, has not been given to him. Stop. Let a copy of the communication dated 3/4/2024 be furnished to Mr. So-and-so, learned counsel for the petitioner. Stop. Needless to list this matter again on
Next week, perhaps, my lord, he will have to take instruction.
Yes.
And there is one another aspect, my lord. I will submit, my lord.
Did you show this very?
on so-and-so date.
24.
Stop. By which, stop. It is needless to clarify that the petitioner shall by Stop. Yes.
Well, I am representing R1, 2, and 3. But they are no longer in service, my lord. So he, on an earlier occasion, but I am just submitting. On an earlier occasion, this honorable court was pleased to direct the petitioner to file his application for implementing the present respondent.
Suppose what you are saying is correct, that the demarcation has been completed. Then why? Where is the need for further
implement?
No, therefore, my lord, since there was a specific direction, my lord, he has not, my lord.
Mr. Borpujari, you are not answering to the query raised, posed by this court. It is your submission that the order of this court has been complied. If that be so, then where is the need for further implement of the new incumbent?
No, therefore, my lord, I am submitting. My lord, if tomorrow he says that it is not complied, so he raises a dispute. If he raises
that
a
is
dispute,
for him.
Yes, my lord.
That is for
then
him.
He will have to implement. Then he will have to implement.
You cannot be blowing hot and cold together, Mr. Borpujari. One way you are saying it has been complied, then you are saying let the new incumbent be implemented. Take one stand.
I am diplomat.
I am obliged.
Yes. Fresh steps. The office note dated 15/3/2024 indicates that the petitioner has not taken fresh steps in respect of respondent number 5. Stop. It further appears that there was no representation on behalf of the petitioner when this matter was placed before the Lawazima court on 15/3/2024. Stop. Today, when the matter is called, also there is no representation on behalf of the petitioner. Stop. Mr. Your name?
U. Sharma. For
U.
PNRD
Sharma.
Department. For PNRD Department.
Learned Standing Counsel?
No, Lord. I am appearing on behalf of the
Learned Counsel for PNRD is present. In view of non-representation of the petitioner, this writ petition stands dismissed for non-prosecution.
Obliged.
It took him 49. Yes.
As per my instruction, earlier contender was retired from service.
But you had earlier taken time to file impediment. What happened?
We have asked for, communicated the representation, but we have not received any
How much
reply.
time do you need?
2 weeks, my lordship.
MS?
R. Begum.
MS R. Begum, Learned Counsel, for the petitioner seeks 2 weeks time to file necessary impediment implication in the matter. Prayer allowed. List after 2 weeks on a date to be fixed by the registry.
Obliged.
Please, Your Lordship. Lordship, my senior is in late pass over the after time being.
Have you taken steps?
Yes.
Lordship, I'm appearing for respondent number 7.
You are appearing?
Yes, sir.
So then, and what about 8? Anybody appearing for 8?
Lordship not shown in the process of.
Office note dated 10/5/2024 indicates that await service in respect of respondent number 8. Sorry. Office note dated 10/5/2024 indicates that service in respect of respondent number 7 and 8 has been completed. Stop. MS K. Bhattacharjee, Learned Counsel, for the Learned Counsel entered appearance on behalf of respondent number 7. Stop. However, there is no representation on behalf of respondent number 8. Neither any wakalatnama has been filed today when the matter has been called. Stop. List this matter after 2 weeks on a date to be fixed by the registry. In the meantime, the respondents shall file their necessary return in the matter. Yes, respondent 3 has filed affidavit. What about the other respondents?
I am for the respondent number 12, Lordship.
Yes, you had sought time.
Yes, Lordship, but fact is that, Lordship, initially, Lordship, this board of management was looked after by the regular body, Lordship, but thereafter, Lordship, one-man committee has been constituted by the rest of the cooperative society, Lordship. Now, Lordship, the tenure of this one-man committee, Lordship, has been expired on 8th of April, Lordship. To my instruction, Lordship, till the 2nd, Lordship, May of this month, Lordship, no one-man committee man has been appointed, Lordship. So we need time to, Lordship, because Lordship,
you are Mr. J.M. Gogoi.
J.M. Gogoi.
Mr. J.M. Gogoi seeks further 2 weeks time for filing the return in the matter. Prayer is not opposed. List this matter after 3 weeks on a date to be fixed by the registry.
Obliged.
53.
Part 3 3 6 3 weeks time.
May I please, your Lordship?
Yes.
Lordship, English Council health is unwell, Lordship. Kindly pass over for day, Lordship.
1 second. Yes, what about the affidavits?
Affidavit, Lordship, we are yet to receive instruction, Lordship. We have communicated, but Lordship, we have not received instruction.
How much time?
Posted after 3 weeks, Lordship.
Mr. K. Gogoi, learned additional senior government advocate
Lordship.
For the state respondent 6, 3 weeks time?
Lordship.
3 weeks time to file return in the matter. Prayer is not opposed. List after 3 weeks on a date to be fixed by the registry.
Thank you.
May it please your Lordship. Lordship, as per laws in my order, is at 13/5/2024, Lordship, service has been completed, Lordship.
R7?
Well, I am appearing for number 7 as legal aid counsel. I need some time to file it.
Mr. K.M. Halloy. K.M. Halloy, Learned Counsel, appearing on behalf of the respondent number 7, 6, 3 weeks time to file return in the matter. You also want to file?
We are always fine.
Prayer allowed. List after 3 weeks on a date to be fixed by the registry.
There is an interim order.
Interim, if any, shall continue till the next date of listing.
Obliged, Your Lordship.
Lordship, kindly we request the registry to dictate our name in a
Registry is directed to reflect the name of standing council.
Not state government.
Government name of government GSM.
Oblige, Your Lordship. This miscellaneous.
Where? 54. I have not entered appearance. Bodler, in order matters, this court doesn't enter names. You are already there. Yes.
Lord, this miscellaneous application is filed for restoration of the WPC, my Lord, which was dismissed for default, my Lord, on 22/4/24, my Lord.
By this court?
Yes. No, my Lord, this was dismissed for default by Honorable Justice Kardec APA, my Lord. And previously this was listed before Honorable Justice Manish Chaudhary, and he wanted to know whether the matter can be posted before the same bench or before the other bench. There is a noting order by the Honorable Chief Justice on 14/5 that this can be listed before the bench which is taking up the roster as per the roster.
As per roster. Okay. Yes, what are the grounds for non-appearance?
My Lord, in fact, in this case, senior advocate S.N. Sharma was engaged, but he expired long back, my Lord. And I was on that day, my Lord, I was at Gurgaon, my Lord.
S.N. Sharma was earlier.
Yes.
And on 22/4.
Cause list is there, my Lord. I was there. My name is shown in the letter of acceptance.
You were, but what about your juniors?
My Lord, R. he was sick, my Lord. He was, my learned friend was asked to appear, but he was in legs in other court.
Which
That
paragraph have you said?
Paragraph 8, my Lord.
All right. Shall be restored, but a cost will be awarded. Heard Mr. Mr. S.K. Kejriwal, Learned Counsel for the petitioner. Stop. Also heard, you're there, Ms. Bodler?
Yes.
M.S.N. Borderloy, Learned Standing Counsel Revenue. Anybody else? Stop. By this application, comma, the writ petitioner is seeking restoration of WPC number 5464/2021. Stop. Due to non-appearance on behalf of the petitioner on 22/4/2024, comma, this court earlier dismissed the connected writ petition for non-prosecution. Stop. Against the said order dated 22/4/2024, the applicant is seeking restoration. Heard parties perused the application. Stop. Paragraph 8 of the application is reproduced hereunder for ready reference. Okay? Paragraph 8, page 8. Reading of the averments made in the application, it appears that this matter was earlier led by late Shri S.N. Sharma, and after the demise of Mr. Sharma, Mr. S.K. Kejriwal, Learned Advocate, was engaged in the matter. Stop. However, on 22/4/2024, when the matter was called, Mr. S.K. Kejriwal, Learned Advocate, was on leave, which is reflected in the cause list of 22/4/2024, which is enclosed as Annexure 1 to the application. Stop. It further appears from the aforementions made therein that Mr. R. Ali, who is also an engaged counsel in the matter, was indisposed on that date because of his illness. Stop. It is further averred that Mr. K. Kalita, Learned Advocate, who is also you are also an engaged counsel, who was supposed to appear in the matter on that day, however, was unable to appear when the matter was called up, as he was on legs in a different matter in another court. Stop. The aforesaid grounds appears to be bona fide and sufficient for restoring the writ petition. Stop. Accordingly, this court allows the application. Stop. It is directed that the records of the writ petition shall be restored to its original file. Stop.
The interim order passed therein, that may be continued.
No. All that you do it when that matter comes. Yes, with a token fee, a token cost of rupees 5,000 to be submitted in favor of association or naam ki Didi Baito. Yes, next matter.
Oblong.
No internet areas in Batasi. Yes.
My lord, I have for condoning the delay of 409 days in filing the review petition. My lord, I have stated the ground at paragraph 3 of my
Yes,
IM.
who is appearing for other side? Any objection, Ms. Borman? All right. 417 days.
409 days. 409 days.
Why? Ground.
Why, my lord, I have stated the ground at
474 or 409?
409.
The
409.
No, because you have stated 474 in your cost title. You have said it 474.
Yes, my lord.
Then
474.
you have corrected it. I don't know who has corrected it. There is no initial. How can the averments be corrected without any initial?
My lord, that was.
Please be careful henceforth.
Yes, my
lord. Heard, Mr.
S.A. Ahmed.
S.A. Ahmed, learned counsel for the petitioner. Stop. Also heard M.S. M. Borman, learned counsel for the state respondent, and M.S. G. Hajorika, learned standing counsel, revenue. Stop. This is an application under Section 5 of the Limitation Act 1963, seeking condonation of delay of 474 days in filing the IAC. What is this IA? The condonation is for filing IA.
IA.
In what? Is there any limitation for filing an IA?
Yes, my lord. Review, my lord. Review.
No, exactly, it's a writ petition. No, further, you please see that cost title once. What IA?
My lord,
no, but how? Yourself.
There might be two things, my lord. That review was dismissed for non-prosecution.
No, the petition was.
Mr. Counsel, you want condonation for filing what?
Review, my lord.
For filing a review.
Review.
Please read your cost title. Read it loud so that everybody can
My
hear.
lord, an application under Section 5 of the Limitation Act 1963 with a prayer for condonation of delay of 474 days in filing that, my lord, IA, that my lord, wrongly written.
So,
review petition.
you see, if you,
Yes,
everything
sorry
is
for
wrong
that.
here. Kindly come to a prayer now. Kindly come to a prayer.
Prayer same.
What is the prayer?
Prayer is also
Then
same.
kindly come to paragraph 4 and paragraph
Yes,
5.
yes, my lord, same. My lord, I am sorry for that.
And you want a disposal on the basis of incorrect statements
Yes,
made
my-
in the
yes.
affidavit? You please make these corrections. How can you make these corrections now? There are so many mistakes.
That part that in IA, not IA, in review petition.
Where is the delay time limit given for filing review in writ petition?
My understanding is 30
This
days.
court is not concerned with your understanding. This court is asking you a very specific query. Which provision of
30.
law, under which provision of law there is a time limit provided for filing review in case of writ petitions? Where is it?
In writ petition, my lord, there is no,
Then,
my lord.
and what is this condonation application?
But review, I filed a review, my
What?
My understanding is that the writ petition was dismissed, my lord. Within 30 days, we have to file, my lord, review petition.
Ms. Burman, I don't think. No. There cannot be a condonation because you see, you will file a condonation application when the statute provides for a time limit, correct?
Yes.
In that case, now where is that time limit given? You have filed this application. Have you done any homework before approaching this court? Yes. What is the time limit? Where is it given that you have filed a condonation application?
That is for, dismiss for default, my lord. In that,
if it is for dismiss for default, then what is the remedy available to you? What is the remedy available
within
to
30
you?
days, you have filed-
What is the remedy?
Within 30 days, you have to file, my lord.
Restoration application.
Restoration, yes.
So
I
where
have-
is that restoration application? This is a
My
review
lord,
application.
my lord, the petition was dismissed, my lord, on merit, my lord. And some mistake was committed in that petition, in the order, my lord. This the apparent case of the record, my lord. My lord, I could not appear on that case because, my
So
lord,
it
my
was
name.
dismissed for non-prosecution
No, my lord.
on merit.
Merit.
So you file
My lord,
appeal.
My lord,
Why are you not filing appeal against that order? What precluded you from filing an appeal? What is this application then? First of all, review will lie against what? If there is an apparent error.
yes.
Now, you are saying that petition has been disposed of on merit in your absence. If you are aggrieved, you file an appeal. Number one. Number two, if you want to file a condonation application, then there must be some time limit given under the statute. You are not mentioning anything. How can this court entertain this application? What do you want to do? Withdraw?
I would like to withdraw, my lord. File an appeal, my lord. Then
That you
limitation
do
may be
whatever
considered.
you want to do.
Limitation part is, my lord,
No,
only.
no. That in that
take into
when you
consideration.
file an appeal, you can file an condonation application where you may seek all you may state all this. Item number
Limitation
2,
part may be
56.
taken into consideration.
Sorry, your name S. A. Ahmed. Heard Mr. S. A. Ahmed, learned counsel for the applicant. Stop. Also heard MSM. Mr. S. A. Ahmed, learned counsel for the petitioner, submits that he does not wish to pursue the interlocutory application. Stop. Accordingly, he seeks withdrawal of the same. Prayer allowed. The IA stands dismissed on withdrawal.
Apply.
Supplementary.
The petitioner has instructed me to intimate that he doesn't want to participate. that.
Your name?
MP.
That is
Mr.
one,
M.K.
one
Sharma's-
submission.
Huh?
There is one submission in this regard. My lord, what has happened?
You have objection for the withdrawal?
In fact, yes, because it will have repercussions. Because your lordship will see, my lord, while allowing the withdrawal, your lordship will make certain observations.
I'm not making any observation.
No, why, my lord? Because when the arrest warrant was issued, he approached this court. And on
That's all right,
2019,
67. Heard Mr. M.K. Sharma, learned counsel for the petitioner, stop. Also heard Mr.
S.K. Talukdar.
S.K. Talukdar, learned standing counsel, Cooperative Society.
Corporation Department.
Corporation Department, stop. Mr. M.K. Sharma submits that he has received instructions from the petitioner not to pursue the writ petition, stop. Accordingly, he seeks withdrawal of the same, stop. The writ petition, in view of the aforesaid endorsement, the writ petition stands dismissed on withdrawal.
There is an interim order,
Interim
23-1.
order, if any, shall stand vacated.
Yes, my lord, only one observation.
No, nothing observation.
No,
This is
what
a
I'm trying to
withdrawal.
say, respondent, my lord, there is now no impediment for respondent, my lord, 3 and 4 to execute, my lord,
You
the
can go ahead. The interim order is vacated. You don't need any direction from this court.
lordship will, my lord, make it 23-1-2019. Only that date may be mentioned.
Interim order?
Yes.
Interim order dated
23-1-2019.
23-1,
2019.
2019 passed earlier shall stand vacated. You are appearing for the petitioner?
May it please, Your Lordship. Your Lordship, first of all, I most sincerely and profusely apologize for not
No
being
problem.
present on the video. I have instructions from the petitioner, Your Lordship. All their agents' licenses are valid.
All there?
Agents' licenses is valid.
So therefore nothing survives?
No, Your no, Your Lordship. Like the question that arose on the last occasion was that
Renewal of the subject license.
Yes, Your
So
Lordship.
that is valid.
Yes, that is valid, Your Lordship.
So what is to be done now, Mr. Goswami?
No, it can be fixed for admission. So ACC is
In view of no representation on the last occasion, comma, this writ petition was listed today with the remark for dismissal. Stop. Today, when the next paragraph, today when the matter is called Miss
C. Das, Your Lordship.
Ms. C. Das, learned counsel for the petitioner learned counsel for the petitioner appeared on behalf of the petitioner. Stop. List this matter for admission. This matter was earlier for admission or hearing?
came for
Okay, for orders, Your Lordship.
So I'll fix it for admission.
Came in the Rawazima.
List this matter for admission. Stop. After 2 weeks. Because I think it's already completed, right?
Service is complete, Your Lordship.
It appears that service in respect of all the respondents stands completed. List this matter for admission on
After 4 weeks, Your Lordship.
after 4 weeks on a date to be fixed by the registry. Okay?
Highly obliged, Your Lordship.